looks like our webinar is now live. I'm watching the participants go up by a dozen every 2 seconds.
We're live.
Hi, everybody.
We're live. Okay. Hello, everybody. Hello, world. And welcome to another installment of the Michael Sullivan Associates webinars on the COVID crisis. We've done a lot of them. This one is going to be live without a slideshow. So we're daring to dream here and not relying on any slides. It's a question and answer session.
Never look at the slides anyway.
Yeah, we don't need to look at slides. You know, last time, our last webinar was on the new OSHA regs. And man, there's a lot of them and they're complicated. And we realized that we just weren't, we barely even got through the material.
Yep.
There's so many regulations on employers and what they have to do because of COVID now. And it went into effect immediately. So we realized that we needed follow-up. So this is 2 hours long. You don't have to stay for the whole thing if you don't want to. But we gave ourselves 2 hours to just answer questions regarding what all this means. And you know, at the last webinar, it was an hour and a half, and we got a question every 30 seconds. It was really crazy.
We had something like what, 200?
Yeah.
Questions?
Mm-hmm.
So yeah, it was just under 200 questions in that little period of time. Not even counting all the questions we've been getting as a law firm over the last week since we did the webinar. So we decided, Lisa, you did all the heavy lifting, and Eric, me jumped in, and we went through all the questions, sorted them out, and created some FAQs. And we're going to go through those, but we're also going to take questions from you as we go, and that's what we're doing today. So before we get started, though, a few things. I just want to do some introductory things. First of all, I want to say who we are. So Eric with the bow tie is a managing partner of our employment law section at Michael Sullivan and Associates.
Hey, everybody.
Okay. And Lisa is our grizzled warrior.
We told you about that use of the word grizzled.
Yeah.
Oh. Am I going to get sued or something? No.
But has lots of experience.
Yeah, she's works with Eric closely in our employment law section. I'm Mike Sullivan. I'm the principal of Michael Sullivan and Associates, and also the primary author of Sullivan on Comp. And these presentations are pretty much Sullivan on Comp presentations. But what we did is we decided to do it for the whole world, right? We're just going to show it to everybody. And a lot of people are showing up for these things, like thousands of people. It's pretty cool. It seems like people want to know about COVID law. And I also wanted to say a few words about the new OSHA regs in general. One thing I want to say is that they went into effect like immediately. On November 30th, they went into effect immediately. And that wasn't so good for employers because they're like that thick, you know, there's all kinds of stuff you're supposed to be doing. We're doing a lot of it, but it went into effect right away. And what it is a whole series of regulations of what employers got to do to make sure that COVID doesn't spread and that their employees don't get COVID. And I want to distinguish it because it's going to be a pretty complicated world, right? We had all those federal laws about, what is it, FFCRMA? You get that right?
Close, FFCRA.
Okay. Yeah, where you got people get money for being, and then we have federal legislation with the PPP. In California, we had the presumption bill 1159, which set out the 3 different presumptions where it talked about, you know, people that with COVID filing claims have a presumption under a lot of circumstances. And we're not talking about that today, right? And then there was AB 685, and that came out, and we did a bunch of webinars on that. And that was, you know, a bunch of rules about when employers have to notify other employees, right? When there's a COVID exposure, or report to the state or OSHA. That came in AB 685. We're not talking about that here today. What we are talking about is a series of new regulations that came out that applies to all employers. And it's in effect right away, and it's a lot of stuff. So even though this session is supposed to be about Q&A, but I thought it might be worthwhile to just briefly go over the 9 major points that were laid out by the bill. It might be repetitive for some of you, but I thought it might give context for the whole crowd. And Eric and Lisa, you agreed to this.
Reluctantly.
You said 15 minutes, then we're cutting you off.
You're responsible. Yeah. So, okay. So I'm going to just do it. And then why don't you guys give me a little color, okay? And then what'll happen is we'll ask questions. You guys can answer the questions and I'll be the color commentary.
Oh, geez.
Okay.
Okay. All right. So there's nine things that employers got to do. Okay. 9 things. The first is really hard. It's you have to write and implement a COVID-19 prevention program. Like you have to have a written policy on your COVID prevention program and provide training. And that is really hard. It's long. And there's all these specific things in there.
Except we made it easy.
No, no, they don't really tell you specific things, but they leave big blanks. And at the end, I'm going to show you because Lisa did a model that you can use, that you can have, and you can fill in your stuff. And so hopefully it'll make your life easier. It's on our website. And you have to provide training, and it doesn't tell you how long you're supposed to do training, who's supposed to do it, what's supposed to be in it, or how long it's supposed to last, or by when you're supposed to do it. But you got to do training, right? We know that. So that's number one. You know, how long to do this? How long, you're supposed to have this thing right away, right? It's all took effect on the 30th of November.
First, actually.
On the 1st of December.
Yep.
And corrected. 10 minutes. Thanks a lot for making me look bad.
I try never to do that, but
I appreciate it.
Yeah.
I say, Mike, you did that all by yourself. I'm just mitigating the damage. No, it took, how are you supposed to get this done? This massive program, this thing you're supposed to write. And they, on the first day, the DIR sent out a news bulletin. And in it, they quoted the person in charge of Cal Osha, Doug Parker. He's the chief. And he said, these are strong but achievable standards to protect workers. They also clarify what employers have to do to prevent workplace exposure to COVID-19 and stop outbreaks. And then in regards to how long you have to implement all this stuff, I mean, it took, you know, effect the same day they issued the notice. Employers, he says, this is a quote, employers have had little time to prepare for extensive requirements. Mr. Parker says, quote, we understand the need to educate and assist employers as they implement the new provisions of the emergency standards. For employers who need time to fully implement the regulations, enforcement investigators will take their good faith efforts to implement emergency standards into consideration.
I love that part of his quote that said, strong but achievable, right?
Yeah.
That really translates from the DIR to practically impossible, but you're on your own. So thank you for the strong but achievable.
But we're still going to hold you accountable.
Yeah, exactly.
Yeah, well, exactly. I mean, and it took us a good week to get the template together. And that was, you know, attorneys who understand the law, read the law, to draft this thing. I mean, it is very difficult for employers who are also trying to run a business to get all of this stuff together. So we're hoping to help you with that.
Well, he says that they're going to take into consideration that it takes some time to implement the standards. And then, however, aspects such as eliminating hazards and implementing testing requirements during an outbreak are essential. So I think what that means is, between the lines, is eliminating hazards and testing has to happen now. They're not going to cut you much slack on that.
Yep.
And otherwise, we have an indefinite period of slack, which is undefined.
Well, because arguably we're all already supposed to have done that. Right.
Yeah.
So
Well,
that's why they
true.
gave no slack for that particular requirement.
Yeah, I mean, employers are pretty much doing all this stuff.
Yeah.
But like writing the policies, no. Right? The training, no. So, okay, so number one was create the policy, the COVID-19 prevention program. Number 2 was identify COVID-19 hazards with the help of employees. So get your employees together, identify all the hazards, and correct them. Okay? Whatever hazards may be, break rooms maybe, I don't know. Number 3, investigate COVID-19 cases, investigate all the COVID-19 cases, which we're supposed to be doing anyway under Cal OSHA regs. Notify and provide testing to potentially exposed employees. Now this is different, right? It's providing testing. Employers have to provide testing. We didn't see this. This is new. Our expense during work hours. Yeah, okay. Number 4, require physical distancing, mask wearing, improve ventilation, and maximize outdoor air.
as I sit here on the 8th floor of our high rise.
Open a window.
Windows that don't open.
How are you supposed to do that? I don't know. One of the questions we got last time that we didn't answer and we accused because it was silly was, hey, do you guys have any advice? My windows are stuck shut. Like, no, I have no advice on that. Next one, number 5, I think, don't allow employees to return to the work site until quarantine ends and pay employees throughout quarantines. Pay employees throughout quarantines. Now, a lot of people are working at home, so it may not matter, but for those that aren't, this could be a really big deal. We're paying people not to work. Employers are required to pay people not to work.
Yeah, it's basically a new paid leave that before this, we would have the FFCRA, right? But that sunsets on December 31st. So unless it's extended, which we haven't heard yet, then this kicks in. So yeah, you can use FFCRA to do it, but if they don't have that available and they don't have sick leave available, it's on the employer.
Mm-hmm.
Now that the election's over, you would think that Congress would get it together on the relief packages.
Yeah, you'd think.
Well, what they expect is there might be a gap in time with FFCRA. It might lapse on the 31st, but might be renewed when the new administration takes over. So they're preparing for that gap in time, but really with this, there's no gap in time. You still have to provide the paid leave. And FFCRA gives you tax credits where this would not.
Well, anyway, in the meantime, we're paying even if there's no FFCRA. That runs out, we're paying. Okay, next one, report all outbreaks, 3 or more cases in 2 weeks to the public health department and provide continuous testing to all on-site employees. Outbreaks are 3 or more cases in 2 weeks, and they define a major outbreak here as 20 or more cases in 30 days, where you have to provide twice a week testing. So this was already a part of AB 685. You had to report it to the public health agency, but they've expanded it to defining major outbreaks and then inputting the need to provide testing. Yeah. All right. Number 7, number 8, an employer provided housing. And the migrant workers, they haven't got a lot of love so far, right? In the relief packages. But this seems to pertain to migrant workers mostly. I mean, the bunkhouse rule is a part of Sullivan and Covet that has not been accessed in like 7 years. But now it's like, oh, hey, bunkhouse rule, like people are bunking together. Beds must be spaced and daily disinfection is required. And then an employer provided transportation. This is the last one. An employer provided transportation. Workers get screened before boarding, sit apart from each other, and wear face coverings. So if employer provided transportation. And that's, in my mind, an open question as to what constitutes employer provided transportation. We talk about that. So those are the 9 things. I want to point out that the Osha website, Osha has done some stuff. They did some stuff, okay? So they posted a fact sheet. Ours is better.
Much. Their fact sheet is terrible.
They have posted a model employer policy, COVID policy. Ours is better. They have provided various free training for webinars. I don't know if ours is better. We're still doing it.
Well, for that one is they give you a training option, and a lot of employers are going, how are we going to do this? Do we have to pay people to come in? And the answer is they've already approved that training for your employees. So I don't know how you feel about it, Lisa. I'm telling people use their training. They already said that's the training.
Yep.
Just use the OSHA training. It's approved.
It's approved. There's a link and it's free. So so I would take them up on it.
Okay. Well, that's good advice. I just got an email from a client this morning saying, hey, from a TPA saying we want to create a training and we want to show it to our clients. Will you help us? And we've been doing that a lot, our clients.
Well, and the thing is,
tell them, hey, yeah, sure, we'll help you. We'll help you form your policies. We'll help you. We'll be available for advice. But maybe you just want to run the Cal OSHA training through with your people.
Right.
And then just listen to our stuff if you want to find out more in depth, more a deeper thought process about it.
Yeah, for being compliant with the regs for those, because all the employees need to have this training. Everybody does.
Yeah.
You know, that free training makes sense. For, you know, businesses, you know, of all sizes and employers, they should probably have their own direct training because, you know, they have to comply with all these rules. You know, it's a different type of training.
Right.
So
I'm gonna share my screen, okay? And wish me luck that I don't screw this up. The reason I'm going to share my
better
screen,
you than me.
Yeah, me too.
I've gotten pretty good at the Zoom stuff. It's just like, there's no actual evidence that exists physically. I could be a computer generation. Anyway,
No, we know you exist, Mike.
Yeah.
thanks, Lisa. I'm sure you meant that in a complimentary
I was
fashion.
going to say, like, just take it as a compliment.
All right, so I'm going to share my screen, and what I'm going to do is show you the resources that the firm has available. And in regards to this, we have a fact sheet in our ebook on COVID, which we just posted this morning, and which will contain most of the questions we're going over today. And then also we have a sample of a plan that we put together for employers. So let me show you. So what you do is go to sullivanattorneys.com, sullivanattorneys.com, Michael Sullivan and Associates, right? I think I have it here. And can you see that? Yeah.
It is.
Yes.
Bingo.
It's a website. And then over here on the very right is COVID-19. Now, we have a book called Navigating COVID-19. And it's an ebook, and it's about, we've printed it out. It'd be like 300 pages long. We're modifying it every day. And it tries to answer every single question that there is in workers' comp. So let me click through to it here. Okay, it takes it here. Access now. Okay, let's access now. And here it is. It's got all the pages. So here's, it's the introductory sections, and we have workers' comp section and an employment and labor law section. Here's all the different topics. You go down here, Cal OSHA imposes safety regulations on business, and here's the fact sheet that you can click on, and it's got all these questions and answers. See? Cool, huh? And that's the book. And like I said, I mean, it answers every question that there is about COVID that we could think of or that we've been asked, which is everything. It tells you whether you don't know, but it's all in there. So hopefully you'll find this useful. You can bookmark it. It's free. We have close to 1,000 people a week looking at it. So we're really hopeful it's helping to guide the industry forward. Now, let's see if I can get back to the firm website, because it took me to the book, which I think is a different link. Oh, I got to go over here. Okay. So if you go to the COVID-19, now you can see the updates, our webinars. This is number 21 on the webinars, but let me just show it to you anyway, just so you can.
No, we're on 20. 21 is next week.
21's next week.
Yep.
So here are part one, all the issues, workers' comp, employment law, claim form, return to work, AOE, COE, interviewed Jacobs-Meyer, who was in a coma for a month with it. Spoke with the doctor about it, the medical, et cetera, everything is in here. And so you can look at these, and they're all certified. You get your credits for them and everything like that too. And so we have updates and our own personal performance continuity plan. And finally, under resources, we have a whole number of different handouts, sheets we've created. Like for example, the presumptions FAQ, and there's a presumptions sheet for employers and carriers. And there's a sheet on the different notification and reporting requirements for employers. All these kind of things are all in here. They're really helpful. The one we want to talk about right now is the prevention program. This is a model prevention program. You can go into it, fill it out, and comply with the law's requirements. Okay, so you see it's all the things that it says you have to have in there. And we figured out what should be in there. And if we left the blank spots for you, if you need to fill it in for your own company. So sometimes just your company name, sometimes you'll have to put in policies and things like that. It's really cool.
Right. It allows for you to put in your particular company's unique policies and procedures related to these items that are required by the regs to be in this prevention program handbook.
Yep.
Okay.
So we got the basics in there for you.
It's available to anyone that wants it. Okay. I'm stopping sharing screen now. The last thing I want to say is that if you have questions, I think we disabled the chat for this one. We already have 20 questions, guys. And
So
so
chat, but not Q&A. Q&A is still open.
the Q&A is open. And what I wanted to ask you to do is if you have questions, then please go to the Q&A and put in the questions, and we'll go through the FAQs that we have, and I'll try and screen out the best questions I can, and we'll answer them for you. If you don't get your question answered, just email us. The email's on the website, and we'll be happy to contact you and help you with whatever problem or issue or question that you have. But as we go,
Mike, I just want to mention that the last time we did this, our last webinar, when we talked about the regulations, we asked folks to submit questions, and you did. And the questions that we're going to answer today are those questions. So if you have been waiting for an answer to one of your questions that was asked in the last webinar, you're going to get your answer right now.
okay. I see a lot of good ones right here. I want to skip right to them, but I'm gonna go to some of the questions on our FAQs just to start us off. And then as we go, folks, if you want to add questions that pertain to what we're talking about, that'd be great. Although I already have 26 questions.
A lot already prepared that were already asked that are very good too.
Okay, here we go. Ready? Let's ask some questions. This is the part where I stop talking so much and just ask questions, and you guys say intelligent things.
Well, we'll do our best.
Okay. So I think the first one we had is the scope of it. Like, what about employers that have just one employee? What about that? Does this apply to them?
So as long as this employee is not around anybody else, then it does not apply to them. And if they're working from home, right, remote, you have everybody's working remote, nobody's around anybody, similarly so.
Okay. What about, we have a question here about what about employees who work from home but occasionally come into the office? Do the Cal OSHA regulations, are they applicable to the business?
What do you think?
Yes.
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 Come on.
Absolutely.
It is. Okay.
So, you could mandate that all employees work from home exclusively and that they are not allowed to or authorized to come to the office. And maybe that's a way around the applicability of these regulations, but you'd have to know for sure. You have to lock the doors, change the locks, that kind of thing, to prevent employees from coming into the office.
And along those lines, one of the requirements with the new regs is that employers determine if there's other options than to coming into the office.
Right.
So and this is along the lines of, a lot of these things are things that employers were already doing because there were recommendations. They didn't necessarily have to do them at all times. But now, if the employer can have these people working remotely based on the reading of the regs, they may have to, and as of now, immediately. So an employer has to say, hey, can we get everybody working remotely, not just because you want them there, but if you can get them to work remotely and get the same job done, then by the reading of the regs, you have to do that now.
Yep. Well, and the shelter-in-place orders, you absolutely have to do that now.
Especially now. Yeah, exactly.
Okay. What industries or employers fall within the aerosol transmissible disease standard? What the hell is that, by the way? I'm sorry, what the heck is that? And therefore do not have to comply with the Cal OSHA regulations. You don't have to comply if you fall within the aerosol transmissible disease standard. What is that?
Do you want me to take that, Eric?
Yeah, I mean, it's complicated. We have it in the FAQ. It's usually medical, it's hospitals and that type of thing. So it's an analysis, but it's not it's really specific just to an employee evaluation, what their jobs are. It doesn't mean that all hospitals are excluded from it. It's that employee, what their job is. But
exactly. And it relates to employees who, as part of their job, come in contact with infectious particles, that kind of thing. And so there's like a 50-page questionnaire that employers need to fill out to determine who in their workplace may fall within this standard, and this standard's been around for a while. And so if you fall within the standard, employers are generally required to have a program similar to the COVID-19 program already in place that you're required to follow. So I am not going to profess to be an expert on ATD by any stretch of the imagination, but we do provide some information in the frequently asked questions on the ebook about how to get more information and a brief description of what it entails. But it is generally hospitals, clinics, people who work with, take blood from folks, things like that.
You know, they're doing everything anyway. Hey, I want to mention that I looked at the chat. We disabled the chat for purposes of asking questions, but we did post direct links to the documents that pertain to this subject matter, the FAQs for this and the model. What should we call it? The model
COVID prevention plan.
Yeah, right. Thank you.
You're welcome. That's what I'm here for.
Oops. I almost left the meeting. Sorry, I'm managing my chat.
Don't do that.
Yeah, definitely don't do that.
No, I'll do that. Okay. Yeah, I didn't do it. We're okay. Okay, so next question. Are we now required to screen our employees before they enter our workplace?
And a one big yes.
You have to
Yes.
screen them all? Like
do.
when we go to a restaurant, they put that thing on our forehead?
Just like that.
Exactly like that.
But not on your forehead. It can't touch your forehead.
Right. And you have to wear a mask while you're doing it. But you do have an option of allowing your employees to self-screen before they come into the workplace. But I think as we talked about last time is you will have to pay your non-exempt employees for the time spent doing the self-screening, and you may have to reimburse them at least partially for any equipment like a thermometer that is required as part of the self-screening. So
How do you self-screen? I get that.
well, so the way you would do it is it's typically a checklist and you run through certain questions. It's, temperature. Have you been in contact with anyone who's has COVID, or have you been in contact with anyone who has possibly been exposed to COVID? Do you have symptoms? So there is a checklist that is regularly used by folks that can be used as a self-screening kind of a checklist.
Then you gotta pay them for the time they self-screen. I guess you could have them come into work and screen in the lobby.
Well, and then you still have to pay them, but at least they're there, right?
Yep.
Otherwise, you have to have your own. I mean, what does it mean if the employers screen on site? Does that mean they just take temperatures, or they have to do something?
They would ask the same questions, and they would, do the temperature. The only difference is, do you have a person who is assigned to doing that for every employee that walks in, or the employees doing it themselves? And are the employees doing it in the lobby of the office, or are they doing it at home before they get in the car to come to the office? Because if they get there, right, and then they have 102 fever, you have to send them home, right?
Yeah.
And then potentially you have a reporting time pay issue. You have to pay them for reporting to work.
Yeah, when you get wage and hour claims, those aren't good.
Yeah. And then if they test positive, you've got notice and testing requirements and all that kind of thing as well.
Yep.
So
I got actually a question from the audience that's in connection with the question. Do the screenings apply to school district employees?
Yes.
absolutely.
Yeah. I guess you would have to screen the students. Just employees.
Well, the regs apply to employees.
True.
The regs apply to employees. So I would say the regulations apply to the employees. I don't think that the regulations, unless you disagree, Eric, apply to the students.
It doesn't. But how good an idea is it to have a classroom full of people that didn't test when they walked in, right? If they're having in-person classes, and what does that look like if we're just letting people walk in without doing some type of screening process?
How do we screen a kindergartner?
Right.
You know,
and you have I guess you would have the parents do it, right? You have the parents do the screening. And so I don't think there's a one size fits all, but with the intent with these regs and the other regs that we're seeing in all these orders, I think there's at least some argument that there's a duty to screen people who come into either the school or the workplace.
So that would be students, customers, vendors.
Yeah, so, people come
Yeah,
in.
it's not in these regs, but it's a good idea.
Yeah.
Yes, it's part of your practice in ensuring that you have a healthy and safe workplace for your employees. It's all part of that effort.
Okay, here's a question. Do we have to take their temperatures, or can they still send us the information when they come in for the screening? I guess we kind of covered that, right?
They would have to do their own temperature, but the point that we brought up last time and the one that Lisa mentioned is if you're requiring them to monitor their temperature before they get in the car and come to the office, arguably you have to reimburse them for a portion of the cost of whatever that thermometer is.
Somebody made a comment here. It said the LA County order, parens T1, requires screening of students at schools, but Cal OSHA does not.
There you go.
Then you follow the local order.
Yeah. I mean, we should probably say that there is local orders all through the state, and we're not attempting to examine those and explain it to the world because it's overwhelming.
Yep. And that's why there's a blank in there for that in the template, because everybody has to put in their local orders as well. So when you do these CPPs for yourself, you have to put in what local ordinances apply to you in that city, that county.
Right.
Okay.
And in general, the employers have to apply that law, whether it's federal, state, or local, that provides the most protection or benefit to their employee. So if there's a discrepancy between a local and a state law, you would apply the law that allows for the most benefit or protection.
Yep.
Okay, here's one. Since police and fire fall under the ATD policy, do we need to self-screen police and fire, quote unquote, safety as well?
Well, if in fact police and fire in your organization fall under ATD, and you're certain of that, then there are ATD standards that you have to adhere to. You do not have to adhere to the Cal OSHA regs, but you do have to adhere to the ATD standards that likely address that.
Okay. We had, should we save the screening results if our business activity screens employees as they enter the workplace? Should we save the results?
I mean, yes, you should be recording these. You should be showing that you're doing the work. And if you are doing things like taking temperatures of people and recording it, it needs to be kept in a confidential file, right? So you can't be, have a posting of everybody's temperature, that came in on Monday or anything like that. It has to be in a confidential file, like any other medical information. Similar, if somebody tests positive, you need to keep that in a private file.
Right. And one way to look at this, if you have questions about whether you should or should not do something, the regulations specifically require that you keep documents and records of your efforts to comply with the Cal OSHA regulations. And so this would be one way that you would keep records to show that you are complying with the regulations.
Maybe I can summarize this by write everything you do down and but keep confidential any personal identifying information relative to COVID diagnosis.
Yep.
Yep.
No, you can't tell. We already know this. You can't go around and tell everybody, hey, Bob's got COVID.
Right.
Everyone's stay away from Bob.
It's interesting though, because I do get that question because employers are saying it would make it so much easier in some respects to do the investigation if we were able to say, did you have lunch with Bob yesterday, or did you go to the break room with Bob? Did you spend more than 15 minutes with Bob? But you can't do that. You can't do that. Now, employees generally will be able to figure it out, most likely, if they're working closely with these people and they're gone. But you can't give out any identifying information.
Yeah, it makes it a real challenge, especially finding out who is an exposed person within 6 feet for cumulative 15 minutes in a 24-hour period of time. How do you do that when Bob tells you he's positive?
You almost have to rely on what Bob tells you.
Yeah,
in other words, who Bob was with.
Right. Who were you around? How long?
Right.
And if Bob says something like,
oh, Bob.
Bob. Sorry, Bob. But if he says something like,
COVID guy.
you know, I don't remember, then you do have to do some type of questioning in the, you know, where
Yep.
people were and be more general about it. Although the reality is Bob's not around in the office anymore. So they're going to put the, you know, connect the dots. That's not as long as we're not giving out identifiable information, we're fine.
How long should the screening files be stored? I can answer this one. 3 years.
That's right.
Yep.
Yeah.
Gosh, very good. Woo!
You've been stuck with us way too long, Mike.
Yeah.
I need to show the actual regulation that says we need to track temperature readings. Do you have the actual reg number that I can show them? Do you guys have to look that up?
Is there a reg that says you have to track temperatures?
No,
it says you have to screen. You have to screen.
You have to screen, right? So I don't know that there's an actual reg that says part of that screening has to be temperatures, but
What's the
you know,
reg?
just practically speaking, that is one of the major symptoms of COVID.
This is the regulations. There's a lot of them. I'm sure somewhere it has a screening.
It's about 20 pages.
Yeah.
Okay, email me, baby. We'll look it up, okay? I just called one of our viewers baby. I take it back.
Yeah, thank you, Michael.
That was weird. Okay. What else do we have? By the way, I'm getting a lot of questions. I have 62 so far in the first half hour,
Okay.
like last time. And
Wow.
folks, if you're asking questions pertaining to the subject matter we're discussing in this presentation as we go, then you're more likely to get them answered in the present time. Look, one says, what do you do if Bob says he
Somebody's listening.
I'm going to skip this one because it doesn't pertain to what we're talking about immediately. Can you give out the name of the infected person if they give permission for you to do so?
I think that you probably can, but why would you?
Why would you? And if you're going to do that, I'd have some type of written consent, a written consent, if that's the case. But, you know, I don't know. That doesn't make me feel terribly comfortable.
Yeah, me either. I wouldn't do it.
Because then and then, you know, then Bob says, oh, they made me sign
Exactly.
it. They made me do it. And I don't think that gets us far enough to make it worthwhile.
I agree.
Does the regulation say you have to record all health screening info? No, it doesn't. Not explicitly.
I don't think it says it explicitly, but what it says is we have to document our investigation efforts, right? And we have to document our efforts to, you know, maintain a safe, healthy workplace. So we mentioned that, not that it's a absolute requirement, but we have to be documenting what we're doing to some extent. And these are ways you can do that.
Okay. I'm gonna go on to the next FAQ question here. Sorry, bear with me. I'm sorting through a lot of questions. Okay. Yeah, I'm gonna move on to the next. I think we got past screening. And the next question is, how do we determine who may have had COVID-19 exposure? Because, you know, the rule is that if you identify someone who may have had COVID-19 exposure, you got to send them home, right?
Yep.
Well, tell me what the rule is again.
So generally, once you have a COVID-19 case, right, somebody who is actually tested positive, has a confirmed case, the employer is now, as we stand here today and for the last week, is under an affirmative obligation to investigate and document that investigation by asking the questions of the COVID-19 case, who we've already identified as Bob, sorry. And Bob's going to tell us who they were around, who he was around. And was that for a, you know, a hot second, or was that for potentially a cumulative 15 minutes during the day within 6 feet? And if they are potentially cumulative 15 minutes within 6 feet, that person must go home. That person must go home.
Yeah.
So how do you determine who, quote, may have had COVID-19 exposure?
Well, like Eric said, first of all, you talk to the COVID case.
Yep.
And you need to know whether or not they were within 6 feet of any of their coworkers for a cumulative total of 15 minutes in the last 24 hours and during the infectious period. So you have to go back 2 days from the first either positive test or symptoms.
Yeah, but it'd be a lot easier if you could just go to the employees and say, okay, who was next to Bob in the last?
Right. Right. Would be way easier.
Right.
Understand?
But
Yeah.
since when
Yeah,
do they
do
do anything easy for us?
Yeah. So you
Which
can't
is
do-
why, which is why in our template book, as one of the employees' responsibilities, they must cooperate with our investigation into any COVID cases. So Bob can't test positive, go home and refuse to talk to us, right? He has an affirmative responsibility to cooperate with our investigation.
If Bob lives with his sister and his sister tests positive, as Bob's employer, do we need to pay for his test even though he wasn't exposed at work?
So he lives with his sister is positive. He's quarantining at home. I take it.
Yeah.
I would say no.
No.
It's not work related.
And I mean, yeah, exactly. So, I mean, you don't have to test every employee if everybody's been quarantined at home, right? Who tests positive. It's the people that we need to test and pay for the testing are the people who were exposed at the work site. So if you know, that's the sum of it, really.
Can Bob claim he has been exposed to COVID-19 more than once? Can he quarantine multiple times at the employer's expense?
There's no limit.
Yeah.
Now there's, a cap on FFCRA leave, right? And once they've exhausted those hours, now we go into this, new bank of employer paid leave if they don't have sick leave available.
Okay.
So, there's no, well, you already had COVID. So, arguably, we hear that it's supposed to be, after one time, you probably shouldn't be getting it again, but, there's no such cap.
One person asks, what if Bob refuses to cooperate? Is that a fireable offense? I guess they mean that Bob won't tell you about who was around at work. So you have no basis for trying to identify those who may have been exposed.
I mean, I don't know about what you think, Lisa, but I mean, the answer is when people don't follow the policies that you have, especially if you put out this CPP plan, you make people even sign it, say you have to cooperate, everybody's going to have their new handbooks out with all the obligations that employees are going to sign that say they need to cooperate, especially with the health and safety standards. Now, Bob doesn't want to, tell you who he was around or what he was doing. Is that a violation of your policies now? It is. Can you terminate somebody who violates your policies? You can. But when you have it in connection with an illness and somebody has tested positive for COVID-19, say Bob is the only person who's tested positive for COVID-19, and you fire that person. Now, potentially, you're in a discrimination component for discriminating against somebody who has COVID-19 as an argument. I'm not saying that's the reason, but that everybody knows a plaintiff's attorney around under every rock who's going to use those facts and and sue you under that theory. So I don't like that that scenario, but can you, if that is the true reason you're getting rid of somebody? Yes.
Yeah, I think a better strategy is you discipline them. You give them an oral warning of some kind, and then you have to do the investigation on your own without Bob's input. But you do have to do the investigation, but you can.
Yeah, I mean, what if Bob doesn't cooperate, and then you can't go around and ask people if they're around Bob? Now there's no way to know. How are you going to know?
What do you do in that case? You probably exclude everybody who was in that area that worked with Bob.
Can you do that? Can you say, okay, we're doing group, everybody out?
Everybody out.
On the plant because Bob won't tell us who he was around.
Everybody that Bob was potentially around and potentially exposed. And if that's the best you can do as far as information, you can't get closer to, then you absolutely can do that. And you may want to.
I'm getting a lot of questions asking people are asking where they can get the template that were talked about for the plan, the model plan. Look at the chat feature, you'll see direct links. Otherwise, you go to sullivanattorneys.com under the COVID tools section, you'll see it there. If Bob's sister was positive for COVID-19 and he had no exposure at work, can we request Bob to provide the sister's place of exposure, date of test, quarantine dates? Is this a HIPAA violation to ask these questions?
So, okay, so Bob has been quarantining and gets it from his sister.
Yeah,
So he's not been at the workplace at all?
I don't know.
If he hasn't been at the workplace at all, why would you even ask him?
Right.
Well, let's assume that he was.
Okay,
Sure.
so
But is Bob positive or has he just been exposed?
incomplete hypothetical.
All I got is what I get. I mean, I don't know.
So
Say something smart so we get to the next question.
yeah, in the case, if Bob is exposed by his sister and he's been in the workplace, and now we know that Bob has been exposed by somebody who's a COVID-19 case, can you ask Bob, where's your sister been? Yes. Can you ask, is it a HIPAA violation? No, because
No.
employers aren't under a HIPAA obligation, and nor is his sister an employee for SEMA,
Mhm.
right? For California's confidential information.
Right.
So yes, you can ask him where his sister has been, if they lived together, how long they were together, did you go to Target, and ask all those questions.
Mhm.
Okay. If I can't require a negative COVID-19 test in order for an employee to return to work, which I understand you can't require negative COVID-19 test for an employee to return to work. How do I know when the employee can come back to work?
We
Yeah.
outline it for you.
We do. So it is completely outlined in our template book, but in general, it is a time-based test, if you will. If your employee had symptoms, it is 24 hours have passed since there's been no fever without using fever reduction medication. Symptoms have improved, and it's been at least 10 days since the COVID symptoms first appeared. So there are very strict timing tests for if you have symptoms, if you don't have symptoms, and we even go into other types of situations that have timing requirements on it. But the bottom line is, if you have to follow these timing guidelines, but you have to rely on your employees to accurately tell you
Right.
whether or not they've been symptom-free, whether their fever's been reduced, et cetera. Which is why it's so important on the front end of these cases to document, for example, when the first symptoms appeared, right? Has it been 10 days since the first symptoms appeared? But that's the way you do it. And so you have to rely on the self-reporting in a lot of cases.
Yeah, that's the only way you're going to know. And you have to, these questions that you're asking to let people in back into the workplace, you should be documenting what those answers are before you let them in. Because God forbid they come back too early and they infect people, and you have to, show that you followed all of the guidelines. So now there's really only one way to get people back into the workplace. They have to meet these standards that were laid out by Osha and that are in the book. That's the only way you let people back in.
Is that just employees? I have a question. They're building a new school. If our employee is a case, we would notify the contractor, but would we have to test all the construction workers at the site? We talked about this. This is like vendors or outside people coming into the work site. It's
Well,
not.
you have no obligation to test them,
No.
right? The obligation to pay for these testing is for employees.
Right.
Now, notification is a different thing. Notifying them that they're potentially exposed with the new regs, which differ very slightly from AB 685, you have to notify independent contractors, and in the same way.
But we don't have to test non-employees is the answer, I think.
What's that?
We don't have to test non-employees.
Correct.
No.
Now, I would also be very careful. This is a good time at the end of the year and getting into the beginning of the year to make sure your independent contractors are independent contractors, right? Because if we have them misclassified, this is just another thing that you could potentially get wrong because you're not treating independent contractors the same way as employees. And so it's an important analysis at the end of every year, especially this year on the wake of AB 5 and all the, the new.
Yeah, I was going to say, it's amazing how little we're talking about AB 5. I thought we'd be talking all about 2020, but we're busy.
1 year ago, it was all that was on everybody's
All we
mind.
talked about.
Remember? God, I miss those days when 85 was a problem. Anyway.
How come we can't require a doctor's note or a negative test before people can come back to work?
Good question, except it's in the regs.
Yeah, and I think it has to do in part with the practical reality of how difficult it is to get back into the doctor to get a negative test. I mean, if anyone has actually tried to get a test, it is hard to even get a test timely. And number two, many employees will object to having, quite frankly, to pay a copay to go to the doctor to get a negative test. And a lot of doctors aren't doing it.
Yep.
A lot of places aren't doing it. So as we said last time, if you want a negative test, or if you want to be able to control the testing a little bit more, you've got to have a relationship with a testing organization that will do that for you and do it for you quickly.
Yep. And Lisa and I talked about this already, what a conflict of rationales this is, of saying, hey, you can't require a COVID test because it's hard to get a test. But employer, you're required to test them. And if there's potentially 3 or more people, you have to test them every week or potentially twice a week and get results.
Mm-hmm.
Okay.
Yeah.
so there's a lot of conflicts in these regs, but in any event, we have to figure out how to apply.
Well, if you're required to test, that implies to me that the employer gets to see the results of the testing.
Oh, well, yeah.
Oh, yeah, of course.
So that's okay, but like asking the employee for their own test is not.
Requiring a test to have them come back into the workplace.
Right.
So in order for you to say, you cannot say, we'll let you back to work on Monday, but we need a document that says you're COVID negative. You can no longer do that.
Okay.
Right.
I'm not even sure, and Eric, we talked about this a little bit, that if a doctor says you can come back to work, that you can circumvent the timing requirements. That you can't rely on a doctor's note either. You've got to follow these very strict timing requirements.
Yeah, there's no exception to that. There's well, if you get a medical certification, they can come back early.
Right. No.
You have to follow this.
There's a comment here. Somebody said, Osha said the reason that they do not require a negative test is because the PCR can still provide a false positive even after all the symptoms are gone and are not in the.
Yeah. And that's true too.
That's true.
Yeah.
Yeah. So they said the test isn't a be all end all. So we're going to make sure to abide by this quarantine time standards just to ensure, because we can't rely on the tests.
That's true.
And what's interesting about the quarantine time standards is they are different from what the CDC is proposing. They're longer. And I've had clients say, well, can't I follow the CDC, which is recommending a shorter quarantine period? And the answer is no. You have to follow the California regulations.
Whether it makes sense or not, it's the law. Yeah. Okay. If we use the contact tracing app, that is used by anyone who comes into our work site, is that sufficient, or must we do additional investigation to determine who has been possibly exposed to a COVID case?
So I would say that if the contact tracing app is capable of identifying all of those folks who fall within the definition of COVID exposure, that is within 6 feet of a COVID case for 15 minutes in the last 24 hours, then maybe you can use that as a part of your investigation. But if your contact tracing app doesn't provide you with that information, I think you still have to do the investigation.
Yeah, it's going to have to be a really good contact tracing app to supplement all of the requirements we have for investigating. So I think it might be a good resource, but I doubt it's going to check all the boxes.
I agree.
Right.
Yeah.
Okay. We're going to get into quarantine. We are up to 100 questions.
Wow.
Yeah. And we're getting to some of them, but we're going to get into quarantine. People are really asking a lot of questions about quarantine. They're really interested in this concept. It's tough. So let's just state the basic rule again for me. Can you do that again for me? Under what circumstances do you have to quarantine somebody?
When they are within, if you have a COVID, and correct me if I'm missing anything, Lisa, if you have a confirmed COVID case, somebody has a confirmed test positive, an employee, and then we do our investigation and we find out that they were within 6 feet for a cumulative, not consecutive, cumulative over 24-hour period, within that period of time, within that distance, then you have to exclude those people.
15 minutes within 6 feet over a 24-hour period.
Correct.
Then they have to be excluded, which means they have to be quarantined. They have to be sent home.
Which means they have to be quarantined and they cannot come back.
And you have to pay them. You have to pay them.
And,
Well, not necessarily.
well, if it's not work related,
Right.
Right. There's some exceptions.
If it's
Which is
work related, meaning that the exposure was to a COVID positive person at work, then you have to pay them.
Yep. So
Yeah.
it's good we get into this because we got a lot of questions on this issue also.
Mhm.
Is, there's exceptions to this requirement to pay them. Now, you've excluded people who were exposed within that definition. Now, how do you pay them for this period? Well, this falls under an FFCRA reason, so you probably should be going there first if they haven't used it up, because you get tax credits on that, right? So why wouldn't you do that? Now, they also say that you can use their sick pay, which is not necessarily their PTO, because sometimes employers lump in vacation and sick into one PTO program. It doesn't give that authorization. It says you can use their available sick pay. So if they have available sick pay, you can use that to pay them, right? And you can also use, EDD benefits, that type of thing to supplement. But if all of that is exhausted, then this comes out of the employer's pocket. Now, one of the exceptions is you don't have to pay them if the exposure is not work related.
Mhm.
So that doesn't mean, so the question I've had is, oh, well, this COVID-19 case, they got it from their sister, so we don't have to pay them. Well, no, that's not the question. It doesn't matter where the COVID-19 case got it. It matters where the exposed person in the workplace who's being excluded, where they got it, right? So you're very rarely going to find this not work related for the COVID exposure, unless maybe they went out to the bar together and that's the only place the COVID-19 case and the excluded employee were together. Well, that's not work related. So if that's the only way they were in contact, then you don't have to pay that person. But that's not going to be very, very frequent.
You also don't have to pay that person if you can somehow send them home and they are able and available to work, and then they can work from home.
Absolutely true.
Right? I mean, you're still paying them, but they are working, right? You're not paying them, in other words, to sit at home and quarantine. You would be paying them for working while at home.
Okay, so one of the questions.
Sorry, Mike, if you're able to come up with any jobs, any projects that exposed employees could do if they're able, right? They're not displaying symptoms. They're not positive. They are just quarantining because the regs say, then you don't have to pay them, right? So you should think about that now, if any of that type of work would be available.
Yeah.
So one person asked, if an employee takes leave due to COVID-19 and remains on a leave of absence by their doctor, can their workplace place them on COBRA? I mean, and then she asked, or how would the employer cover the lost time period? The employer currently covers the employee under COVID supplemental paid sick leave. I don't really understand that question.
I don't think I understand that question. Under the regs, if this is someone who you have to pay, you have to keep their benefits and seniority intact, and you have to return them to their position, right? So it's kind of a job protection. But if they are COVID positive and they're out of the workplace, and I would imagine they're out of the workplace longer than 2 weeks because they've got COVID and it's bad. I think the question might be, can we put them on COBRA if they extend beyond what our typical COBRA period is? Usually it's like 12 weeks, 3 months. Someone's on leave for more than 3 months, they automatically go on COBRA because that's what our medical plan says. If that's the question, I imagine you could. What do you think, Eric?
So you can accept, this is the problem. Is the COVID-19 case now fall under ADA, FEHA, or FMLA, CIFRA?
Right.
So if this is a serious health condition, you have a medical note, somebody has COVID-19, they have complications because of that. It's likely going to be a serious health condition under FMLA and CIFRA. And you, during that 12 weeks of FMLA, CIFRA, you have to maintain their benefits. You cannot put them on COBRA during that period of time. Now, say FMLA, CIFRA is exhausted, that's all gone. We're in, the third month. Now, potentially this person is protected under ADA and FEHA as a disability, potentially, but there's no obligation there under ADA and FEHA to continue those benefits without issuing COBRA. So in that circumstance, I think you can issue COBRA.
Yep, I agree.
Well, here's what our questions and the facts I think I know the answer to after what you just said. Employee A was exposed to someone with COVID-19 and needs to be quarantined. Do we then need to quarantine any employees who are exposed to employee A, even if that person doesn't have symptoms or didn't test positive? Is it the fruit of the poisonous tree? Do we have to exclude the people that were?
So if employee A was exposed to, a friend, a sister, a non-employee, then the answer I think is no. You don't have to then quarantine folks in the workplace who may have been exposed to employee A unless they test positive and they fit within that definition of a COVID-19 exposure.
It kind of surprises me because, the whole idea here is someone who's exposed and everyone who was in touch with them well, that's not true.
No.
If you get exposed, everyone around you has to go home. Is that if you test?
If you have a COVID case, everyone around you has to go home.
So if I come to work with Eric and Eric's around me and I have COVID and I go, then Eric's got to go home. But you don't have to go home just because you hung around with Eric.
Exactly. It's unless Eric tests positive, then perhaps I have to go home because I've been exposed to a COVID case.
Yeah, but and that's true with the regs, but there's also there's other practices that employers might want to take into consideration. Somebody is exposed, right? And they may have not tested positive yet, but they were around other people. Maybe you want to say, hey, let's everybody work from home for the next, few days while we sort this out. Yeah. As opposed to getting everybody infected because you're waiting for a COVID case. Right.
Right.
So, we have to we can be compliant with the regs, but, and still, misstep in common
sense.
Can
you send people home just because you think it's a good idea?
You can send people home now. You might be
as long as you pay them.
Well, no,
okay. What I'm saying is everyone's happily working away and you decide in excess of caution, you're going to send everyone home because let's say Bob doesn't want to cooperate. You don't know the scope of exposure. People aren't going to like that. They're going to say, hey, you're sending me home for no reason. You can do that. You just send people home just because you think, well, you have a speculation that there may have been contact with COVID positive person.
In your hypothetical, yes.
Yes, absolutely.
And
you don't necessarily have to pay them.
Well, if you're excluding somebody because you think they're exposed, you would. If you're just saying, hey, you know what, this is getting a little too close for comfort, let's everybody work remotely from home. Obviously, you can do that.
Well, no, what if you can't work? What if it's, Tesla? Can't work remotely from home. You're supposed to be on the factory floor making cars.
Yeah. Well, unless they are exposed, you don't have to necessarily pay them, right? If you're sending everybody home. So if they're exposed case, but employers can send people home all the time. You can send people, home for no reason and say
you can get into a big discussion over sending exempt employees home if they are ready, willing, and able to work.
True.
But that's a whole nother discussion. And what we're talking about here really is a public health issue. It's not an issue of we just don't want you to work today, go home. It's a public health issue. You're sending people home because you are trying to keep everybody safe. right? It's not because, oh, we just don't feel like paying you this week.
Yeah.
It's a difference.
The next question I had was, are employers able to bring back employees prior to the 14-day quarantine period if their physician provides a return to work clearance?
No.
No.
There's
Doesn't
no
matter.
exception. There's no exception for return to work by a doctor, medical cert in the regs.
Yeah. Okay.
The only way you can get an employee back early or not have to quarantine an employee is if you make an application to Cal OSHA. And if you say, if we lose this employee, there's going to be, health and safety concerns for the community. Very, very high standard, but that's the application you would have to make. And you don't get to make that decision by yourself.
And it's not, it's hard on the company. That's not the standard.
Exactly. That's exactly right. And this is different from, essential workers versus non-essential workers. I've had questions about, we're essential workers. We have to stay open, and we have to allow our exposed but asymptomatic employees to stay until they test positive. Well, no. That's not the case. Even if you are an essential worker or you employ essential workers, if they are exposed per the definition, you must send them home.
Well, what about the special exception for Cal OSHA for essential businesses?
There's not.
What's that?
There's not for essential businesses. There is an exception that you must apply to Cal OSHA and say it will be a detriment to the health and safety of the community if this person is forced to quarantine. Not to my business, but to the community. And you have to make that argument. So it's not, I'm an essential business, so Cal OSHA let us stay. You have to show it would cause a harm to the health and safety of the community. So, for example, a whole department in a hospital may not be able to close down because it might be a detriment to the health and safety of the community.
Okay. Here's one. If an employee is exposed to a COVID case at a job site and they exhaust all their avenues of income, FFCRA, sick leave, vacation from previous quarantine, and they can't work from home, should the employee file for EDD benefits before the employer has to pay the employee for quarantine?
Before, no. I mean, I think they have to pay for that pay period.
I agree, and I wonder what EDD benefits we'd be talking about. If they've just been exposed,
Mm-hmm.
I'm not aware of any EDD benefits they would be entitled to.
Nope.
So in that case, you'd have to pay them, assuming they meet all the criteria of earnings continuation. If they do have COVID and they're a COVID-19 case, that is different, and they may qualify for state disability benefits.
Right.
Yeah. So EDD is not going to mitigate the employer's obligation to pay for someone during quarantine if all the circumstances conspire to make it just an out-of-pocket payment by the employer for the person doing nothing. They have to pay it.
Right.
They have to pay it.
EDD. Okay. One person asked, can the workers' comp carrier pay the employee? I think the answer to that is, well, I mean, if the person is filing a workers' comp claim and it's accepted and they're getting benefits, that's different.
As long as they're getting full pay, right?
Yeah. Okay, let me ask the next one. The regulations require that employers conduct quote unquote periodic inspections to identify unhealthy conditions. This is the part where we said you got to search out and destroy the unsafe conditions with your employees, right? So the regulations require periodic inspections. What does that mean? And do the regulations provide any guidance? What is a periodic inspection?
Good question.
Yeah, it's a great
And
question.
who knows? Well, I mean, Eric, what I would do is I would recommend, based on your business, what you do, how closely employees work together, how many employees you have on site, all of that. Based on your business needs, you must determine what periodic means and how often you need to do these inspections, again, to keep your workplace healthy and safe. It might be every day. Every day, you might need to walk the floor and identify hazards. It may be less than that. For example, if you're, basically an office environment and you got employees coming in maybe once a week. So it's going to depend on your business, but I strongly recommend coming up with a schedule and putting it into your prevention program.
Yep.
And then actually doing it. You absolutely have to do it after every COVID case, though.
It's
For
stressful when the government tells you to do something and they don't tell you what it is that you're supposed to.
Exactly. It is. Right.
And the answer is you have to act reasonably.
Mm-hmm. Mm-hmm.
So we all know what that means. That means litigation.
Yeah.
Yeah.
Reasonable to one person is not reasonable to another.
Yeah, and that's why we also said, hey, I mean, there's so much here. There's so many obligations on the employer that you like assign like a person or a couple of people to try and implement this and get good at it, because it's just going to be a cluster. So somebody getting good at this and having this as part of their job duties to make sure these things are done is probably the way to go, especially the investigations, that kind of thing.
Yeah, I agree. Leaving it to your supervisors and managers who are untrained is not the way to go at all.
No, it's like a full-time job doing this stuff.
Yeah,
though.
it is.
Yep.
You got like
Well,
a
I mean,
hire,
Yeah.
it's like a consultant or a full-time person just to do all this crap.
Mhm.
In order to keep your employees safe.
Yeah.
Hey, you're gonna like this. Someone said, I have to leave, unfortunately, but thank you so much. You're all an amazing resource.
Aw,
Aw,
thank you for
Is that
joining
nice?
us.
thank you.
I forgot to mention at the beginning, if we're gonna do one on vaccines next week. I wanted to mention that. It's gonna be cool. We have a Dr. Eli Hendel, I think his name.
Yep.
And me and Eric, and we're gonna do all about the vaccines, how they work, what they mean, what the potential problems are, and then get into like, what about the issues with employers? Like, can they require a vaccine? Can they have it as a condition to return to work? What about the outside world? All kinds of stuff like that. It's gonna be pretty cool.
Yeah, I don't know about you, Mike, but I'm excited about this one because there are, I have a ton of questions from a doctor about what this is going to look like and the realities. And it's on an emergency basis. So what's the difference and what does that look like for employers about requiring, it's going to be fun to, at least have a doctor captive to answer all those questions.
Mm-hmm.
I think it's gonna be real. I'm really interested in it too. I mean, everybody is. It's like, hey, vaccine is the answer, right?
Mm-hmm.
So maybe 6 months, a year from now, we can be back, hanging out at the bar with our friends.
Your lips to God's ears, Mike.
Yeah, the book might actually be open. Yeah.
It'll be a hell of a party when we finally.
Uh-huh.
Oh, yeah, that's true.
Someone said, what? Eric said full pay. Are you saying we have to pay them full pay the whole time for COVID? I thought we paid COVID pay then TD, not full pay.
Yeah. So what you're thinking about is FFCRA, right? Type of leave. Now, the employers have added with the new regs under Osha, this new obligation that they get full pay when you are excluding an employee from the workplace. They're not necessarily a COVID case. They're being excluded because they were exposed under the definition, and they need to be paid and get all their benefits, right? So we had some caps and limits before under FFCRA and TTD and all of that. Those caps don't apply under these regs.
Someone says we have employees asking if they are entitled to hazard pay. They, as essential business workers, teachers, are exposed by simply coming to work. Any merit to that if we're following safety? I don't even know there was high hazard pay for teachers.
There's not. There's not. Nope. No requirement to pay hazard pay. No.
Okay, we'll have to talk to the union rep about that then, I guess. A new form of payment. I will be out of the office next week. Will there be a catch-up session? No, but our webinars are all on all on our websites. Look at this. Holy cow. So when do you people rest? Awesome research.
Recently, not very
Not so
much.
Thank you. Thank you, Patty, for that. I did do this all day on Sunday.
Yeah. Yeah, Sundays have become our new
Me
Monday.
Let me see what else here. Does the employer have to accommodate an employee's request to work from home due to COVID-19 second wave? Meaning I'm scared to go to work because I think this is off topic. This is probably more, it goes to the discrimination stuff that we have in the book, in our ebook. But I think he's asking, like she's asking, what, I don't want to go to work because I'm scared of getting COVID and we're having this second wave and it's higher risk and I'm going to stay home.
Yep. So generally, the I'm afraid of COVID is not, a reason or a requirement to let an employee go home. Now, that there's caveats to that. One of them being these new regs say if an employer has to determine whether or not employees can work remotely, and if they can, they must.
Mm-hmm.
And under the new regs, it's not an accommodation. It's because they can and they must under the new regs. Now let's take these regs out for a second, because they're around for 180 days. Is it an accommodation because somebody's afraid to go home? No, because they don't have it. They're just afraid of it. If they tell you that I have a mental health condition that makes me more susceptible to being afraid of this and cause me panic attacks, then you ask for a medical certification that there's a disability that requires them to work home because of the new way. That's an accommodation under ADA and FEHA. So there's a bunch of ways to tackle. It really depends on the fact scenario. So there's not a blanket, but the blanket no is if the only reason is that they're just want to stay home, they have no underlying medical conditions, that's not a reason to stay home.
Exactly.
Yeah,
but if they do have a medical condition that makes them at greater risk for getting COVID, and they come to you with the doctor's note that says it would, one of the restrictions is I should be working from home, then you have to follow your own FEHA ADA policy of going through the interactive process, determining whether you can accommodate, things like that. These regulations don't get rid of that requirement. And as a matter of fact, part of the program has to be how you're going to accommodate these people. And so that is addressed in the program as well.
And it brings up another good point of, and I hear this a lot, are employers that happen to know about an underlying medical condition. And they say, well, I should send them home, right? Because they have an underlying medical condition. And the answer is no, because they haven't asked you for an accommodation, right? Until somebody asks you for an accommodation because of a disability, then your obligation does not start. And you don't necessarily want to do that because now you are treating them as if they're disabled. You're regarding them as disabled. And that is just another kind of mess. Lisa and I had a 6-week trial on that issue alone. And you don't want to regard anybody as disabled until they give you that medical cert, until they raise it as a disability. You don't want to assume it.
Exactly.
Oh, we won that trial in case you didn't know already.
I know the answer.
We never get tired of saying we won.
Okay, I have the next one I know the answer to. Where does the pay have to come from? Can we require sick and vacation time be used first? Answer is yes, you can.
Sick.
Oh,
You're half right.
yeah, you're half right.
Not vacation, sick.
Okay, not vacation, no. But sick pay, yes. FFCRA, special COVID pay, everything gets used. But sick pay is before you have to pay them to sit at home and do nothing. Okay. This is such a great resource, but also a lot of info to take in at once. Can we watch this again? Yes, it's on our website. You can watch it anytime. Did I just say that?
Yeah.
Yes.
We said it again. It's great.
I'm having a senior moment.
I mean, we assumed an hour and a half last week when we went through this would be enough. And we barely got through the material. And now we're here, a week later, not even going through the slides. And I apologize, Mike, for telling you I didn't think 2 hours was enough, but
Yeah.
here we are with another 100 and something questions.
We could do this all day.
Yeah.
We could do this all day. And we do this all day.
We do this all, whether you're listening or not, we do this all day. Yeah.
Let's see. A teacher is doing distance learning and the district gets a waiver to open classes. Can the district require the teacher to come back to work live, or does the district have to allow them to teach at home? I don't know what a waiver to open classes is.
I don't either.
Yeah. So, and I don't either, but under the new regs, if they can work from home, they pretty much have to, right? If they can do it remote, you'd have to have a really, whatever, it depends on what the reasons are for bringing them in person. I would guess, but if they can work from home under the new regs, they have to.
Okay. Okay, let me get us to the next question. If we determine employees have been exposed to COVID-19, how soon to a person with COVID-19, to Bob, how soon must we offer testing?
Oh,
Well, the regs don't really say.
Yeah, they don't. They don't.
Yeah.
But I mean,
I would say fairly quickly. You know, you can't say a week from now we'll provide you testing. So to me, I think it's really important that employers figure out now, before they get a COVID case and have to deal with this, how they're going to get people tested. Is it going to be a relationship with a vendor, a CVS, or some other kind of clinic that will do this test? Is it identifying a free clinic that you're going to have your employees go to be tested? And will that free clinic be open during work hours? Because that's the requirement. But now would be a good time to figure out how you're going to handle this requirement when you get your first case. I would say it needs to be, though, as soon as practically possible.
Yeah, and we talked about, well, do we have to do rapid testing? And I don't think there's anything in the regs that indicates that you have to pay that extra money for a rapid test. But it gets a little bit murkier when we're talking about like outbreaks, and especially a major outbreak of 20 or more, because you have to test them twice a week, right? There's twice a week testing. So for those situations, it might imply having to do a rapid test, because it's 3 to 5 days for the free test typically.
I thought they didn't even work. I thought rapid tests were questionable.
I mean, there's multiple different types of rapid tests, by the way. And none of them are a full, a full bill of health, a clean bill of health. Right. So are they worse than the 3 to 5 day? I don't know what the answer is to that.
Someone said here regarding how soon to get tested, I believe CDC said a few days, because you may get a false negative if you test too soon.
Yeah, and that makes sense. And there are a lot of employers who test folks by sending them test kits, and they do the test at home and they send it back. That's a really common way for some employers, larger employers, to test their employees.
Yep. And a lot of employers provide a medical health plan, like say it's Cigna or something like that. They give you a free test. They send it to your house, you test, they give you a FedEx, label, you put it back in and you get it back, and that's all free. And I think that falls into things like that. I think fall into the free option that you have to give.
I agree.
Yeah. Someone says, if your medical plan pays for the test, can you direct them to do it on their own?
As long as it's free. Yeah.
Okay.
It only says you must offer a free testing option, and that is you're paying these premiums for a good health plan that gives this for free. I think that qualifies.
Okay, here's one. We require employees to report any COVID-19 symptoms to their manager, who then completes a report. Is this sufficient to adhere to the Cal OSHA regulations?
So the part about requiring employees to report symptoms, that is a good instruction. That's an important instruction, and that instruction should be in your prevention handbook. So an employee reports symptoms to a manager. And I would imagine, practically speaking, that's how it's going to work, right? That the employee has symptoms, they're going to talk to their manager. Their manager needs to be trained, however, to advise someone in management or the COVID-19 coordinator, if you have one, as to what to do after that. Because action must be taken at that point to what the regs call exclude the employee from the workplace. So yes, it's okay if an employee tells a manager who does a report, but the manager must be trained to report it to somebody else, the COVID coordinator or upper management, who then has the authority to tell the employee they have to quarantine.
Yeah, and the reason I was struggling with that because it asked, is this comply with the regs? And you know, the answer of just reporting symptoms to a manager is not enough. You know, if there's an investigation component that has to be documented, and the manager has to know to keep this in confidential file. If this is a COVID-19 case, they have to figure out when the symptoms first started, 2 days before that. You know, for figuring out the period of time of infectious period when you're evaluating who was exposed, because you have to determine the infectious period. So there's a lot to that, those obligations that are not fulfilled by just an employee going up to the manager and saying, hey, you know, I lost the sense of taste and, you know, and I've been coughing, you know, that isn't, and then they say, go home. You're not done. You're not done there.
Right. Exactly.
If they refuse to get tested, can they be sent home without pay?
There's no exception to if they're an excluded employee because they've been exposed during the infectious period. There is no exception to making sure that they get paid for that time, whether or not they want to test.
Right, and the regs say you have to make it available.
Yep.
It doesn't say they have to test.
Yep.
You have to make it available, and you have to pay for it.
My senior brain is not working very well today. I've heard about senior moments, but now it's really I've really started to grasp the concept.
Yeah, I know. I hear you.
Yeah, I've always heard about them, but now I'm starting to.
Now it's true, dang it.
Yeah.
And senior moments last a whole week.
So you get, in order to know that someone has COVID-19, such that other people's could be potentially exposed, there has to be a positive test, right? I mean, just because of symptoms and they go home, that doesn't mean that doesn't mean that now you know they have COVID, so you have to go around and send
Right.
Yeah.
Sure.
What if they refuse to get tested? Then you don't have to send anybody home.
Yeah, that's actually a good question. So if you've got an employee who comes to you with symptoms that you send home, what is the employer's obligation about confirming whether or not they have COVID? That's a really good question.
Yeah.
Thanks. Actually, I made that one up myself.
Can the employer require they get tested to determine whether or not they're a COVID case? I don't know.
Well, I don't think there's anything in the regs that say that is, you know,
Right.
okay to do. What does it look like really is typically an employee has symptoms, they're sent home, and then, you know, they're waiting for a test result, right? In that period of time.
Well, that's what the FFCRA says too.
Right.
You send them home and they, you know, pending a test result.
Right. And are those people that person was around exposed employees for exclusion? Not yet, because it's not a confirmed COVID case.
Right.
But is it a good, depending on how this impacts your organization, is it a good idea for somebody who's displaying symptoms to exclude those people that were around them? Possibly, yeah. Do you have to pay them? Not technically, but you
Not technically.
Not technically, because it hasn't been a COVID case confirmed yet, but you probably should.
And if you want to confirm, I would recommend that you pay for the test of that person with symptoms.
Yeah. Yeah, exactly. And the
Not
reason
a
I
time to
say,
be skimpy.
what's that?
Not a time to be skimpy.
Exactly.
No, and I say this because I've seen this go awry a few times during this, pandemic. People are, they don't want to interrupt the workforce, and, and they're really busy. And then what ends up happening is that they've allowed people to be around each other that they knew could have been exposed. And now everybody, now we have an outbreak situation, right? And that, also affects workers' comp, obviously. So, and now we have all these reporting requirements and notice requirements. So, this is the kind of thing where you err on the side of caution, I think. And we know what the threshold is of what we have to do under the regs. And then there's things we probably should do for, to maintain a healthy environment.
Yeah.
Someone says, I have to go. How long does this webinar go on?
When do you guys shut up?
You guys are great. So we're great. So that wasn't a mean comment. It goes until noon, folks. We got to 1 o'clock. So we have half an hour left.
Yep. Let's see if we can answer all the questions.
Yep.
The one thing we haven't touched on yet is and we talked about it during the seminar, but we haven't answered any questions about it. Just want to make sure it's clear that with these exposed employees, when you send them home, you have to give them this notice that has all the same bells and whistles that is under the AB 685 notice. Now, that requirement, the AB 685 technically goes into effect on the 1st of the year, but this notice requirement for excluding exposed employees is immediate.
Right.
So you should be doing it now. So once you send
That's a really good point. And if I could say that we have a notice for employees that you guys.
Sorry, I'm gone with it. Yep.
If you're going to go to, I showed you at the beginning, our website with all the tools. One of those is employers need to fill out their own stuff and probably work with counsel to make sure it's right. But there's that notice that you can use as a template that we offer for free. We're offering so many things for free, Eric.
I know.
Who's running this law firm? Because whoever it is,
And you get a notice, and you get a
The guy with the
template.
senior moment.
Yeah.
He's running the law firm.
No, it's a resource I think,
Absolutely.
everybody's been asking for, and it just makes sense, right?
Yeah.
Like the ebook. And you can use the AB 685 notice that we have to use it for immediate use if you have to exclude employees. And you probably shouldn't be waiting till the 1st anyway to start doing these notices. Just start doing it.
I'm getting a lot of questions regarding this. So I'm going to ask it. The question is, what about employees who are afraid to come back to work, who are in a protected class and are more susceptible to COVID? You guys talked about that earlier. One of the questions in our facts was I know that several of our employees have underlying disabilities or comorbidities that we're currently accommodating. Do I have to ask them whether they need additional accommodations because they may be at risk for COVID?
No.
Yeah. No.
No, because then you're jumping the gun. They haven't asked for an accommodation. You're assuming they need or want one.
Yeah.
Right. So, somebody has, asthma, right? I know they have asthma, they have diabetes. So maybe I should just ask them if they want to go home. Now, can you do that? You can, but this is, but should you require them to go home? Absolutely not. The problem with doing that is that once you've done that, now you're kind of assuming they have a disability, and we get into that whole regarded as category. So the better practice is, people have, underlying conditions. You wait for them to ask you for an accommodation, and then you make the accommodation analysis. So
and what do you do, Eric, if you get a phone call from somebody who says, hey, I've got diabetes, I'm afraid of coming back to work. What can you do for me?
Right. It's a medical certification. So and medical certifications are so important, and we skip those, especially, in these times. Say, hey, we're happy to accommodate, that. It's not the fear base, is there an accommodation for disability that needs to be done? And that's a medical determination. That's what you need a medical certification for. So still require those, even though we're in these times, because they're important. Or an
Yep.
important part of the process.
They are critically important, because if you don't, then you're setting a precedent that
Right.
other employees may follow, which is, you didn't require Joe to have the medical certification. Why are you requiring me to have the medical certification? And you're agreeing to accommodations that could very well be long-term without a medical certification.
Right.
And by the way, if we haven't told you, we had a trial about this.
We
That
had a
was
trial
hard.
about the- and part of it was that they accepted a non-medical certification. It was a note from a school, and they accepted that. And because they accepted it, even though there wasn't a disability or a need for the accommodation, their FEHA applied because they accepted the note and regarded them as disabled.
Mhm.
So and that's why if there's a lot of caution that we've seen this play out. It's not pretty.
No.
Okay. Oh, we got a couple more quarantine questions. No, sorry. Cal OSHA, okay. Cal OSHA regulations require employees continue an employee's earnings and benefits, even if they are required to quarantine. Specifically, under what circumstances is an employer required to continue earnings and benefits? I think we answered this.
Mhm.
You said you have to continue it.
Yep.
Right.
Unless they can, if they can work remotely, then obviously they're working for their pay. And
Right.
then if it's not work related, which we already talked about, is going to be a really hard standard to meet.
If the employee is eligible for earnings and benefit continuation while he quarantines, but does not have any sick pay available, do I have to pay him anyway?
Yes.
Yeah, you do.
Yeah.
Okay. The employee has already taken his 80 hours of Family First Coronavirus Response Act extended sick pay, and they've been exposed to COVID-19 in the workplace and are required to quarantine again. Do I have to pay them for the second quarantine?
Yes.
Yes.
Yep. If he's excluded from work and able and available to work and the exposure is work related, then you have to pay.
Mhm.
And hopefully they can work, which is going to be, for the most part, they can work remotely.
Mhm.
Okay, then let's talk outbreak. Oh, there is a question about testing. I keep meaning to keep asking, which is if you have them test and you reimburse them, is that good enough? Does that count as no cost to the employee? If they go get a test, I'll reimburse you.
Yeah, we had talked about that, and it doesn't say, it says it's free. And I think if it's an immediate reimbursement, I think that's fine.
I do
think
too.
that's fine. Yeah.
Okay. I think it's okay too.
Yeah.
But what you can't do is say, oh, well, that was too much. We're only going to pay for a reasonable amount of reimbursement.
Yeah, that is, you're absolutely right. And even if they go overboard and they do, what's that?
Show up, a test costs $100,000. I'd like to see a receipt.
Exactly.
Okay. So let's get into, if you don't mind, some outbreak. Let's talk outbreak.
Okay.
Okay. So originally we had SB 1159, which defined outbreak for after July 5th, 2020. There was two presumptions. One's for the cops and firefighters and health workers, and one's if there's an outbreak, right? And the outbreak was defined as if 100 employees or more, it's 4% of the people at that specific place of employment. If it's under 100 employees, it's 4 people. It's an outbreak, right? If there's an outbreak, then the carrier's got to track that, and then they got to say there's an outbreak, and then there's a presumption. But this set of regs refers to an outbreak. An outbreak means something different.
Mhm.
Outbreak, it's not the same definition of outbreak.
It's just three or more for outbreak and 20 or more for major outbreak
3 or more people in a given workplace.
in a work site. Yes.
Yeah, at a work site.
Yeah, which of course has its own.
That's a whole other thing.
Or
Right.
20 or more is a major outbreak. And the reason that they designate people as outbreak, well, I remember that as part of AB 685, if there is an outbreak, then you have to report it to the county health
Mhm.
Correct.
officials, right? But these regs define outbreak in the same way as you would under 685 for reporting to county officials, and do it for purposes of telling you have to give testing to the employees. If it's a regular outbreak, it's once a week, and if it's a major outbreak, it's twice a week, right?
until there's been 14
Right.
days without.
I
Exactly.
got all
right.
that right?
You got all that right. And that,
That's pretty good.
that continues until there's no new cases for a 14-day period.
Okay. So the question we had was, should we follow the more restrictive Cal OSHA definition of outbreak, which is, I guess, it's easier to get one under the Cal OSHA definition than under the presumption statute. Because it's just 3 people, not 4.
Right.
Right, okay. So should we follow the more restrictive Cal OSHA definition of outbreak to ensure that we follow the mandatory reporting that is required during outbreaks? The answer's got to be yes.
Yeah, definitely. For, I mean, always for us, you know, under OSHA and Cal OSHA, it's always our definition. Under 1159, you know, for, you know, you have a more liberal, you know, type of definition. So reporting to public agencies would be the same one. For claims adjusters, I guess would it be different for you? Is there any reason that you would want to use the less restrictive outbreak definition in the 1159 scenario?
Oh, you're asking me?
Yeah.
I wasn't listening. I was getting questions.
Leah? No, so my question, because Lisa and I together.
This is not how this works, Eric. This is not how it works. I'm only asking the questions. Scenario. I'm the moderator.
It's the only workers' comp question.
Yeah.
And you know, Lisa and I know just enough to be dangerous together.
Exactly.
So I can't think of a reason why you would, under 1159, use a less restrictive definition. Would you?
No, you don't. You use the definition that the statute sets out.
Right.
Clear. Yeah. It may meet the definition of an outbreak for purposes of reporting, but I mean, look, the statute itself, 685, delineates 2 different definitions of outbreak.
Yeah.
You use the one that the statute says use.
Yeah. For that purpose.
I know you've been watching the Supreme Court and you think that you can just take the words of the law and make them say whatever you want them to say.
Oh no.
Is of the social agenda you're trying to accomplish. But that doesn't work that way on workers' comp.
No.
You can't go say, Judge, I know the outbreak said 4 people, but in the penumbra it says 3. All right, I'm gonna stop it. All right, let's see. No. If multiple employees work in a large room and are able to distance themselves more than 6 feet, are they all required to wear face covering at all times?
I would say probably not. But what I would do though is I would ensure that there were physical barriers, if that is at all possible, between these employees, because the regs say you don't have to wear face covering if you're the only one in the room while you're eating. And I believe if you can maintain social distance at all times. Is it maybe a nice protection? Probably. And I guess it depends on what you mean by they're all in a room and they never get within 6 feet of each other. Well,
yeah, I don't know what that means either. I mean, if they're in, you know, a regular sized, you know, conference room and they're 6 feet away, I would still require them to wear face covering. And if, you know, they're in a big warehouse and they have, you know, the warehouse is technically just one big space and they're, you know, distance, probably you're not required to. But I mean, these mask requirements, where we were following CDC guidance before and putting these, you know, in place to be safe. Now we have to. Now if we don't do it right, then it's a technical OSHA violation with all the penalties that go with it. So I would err on the side of making people wear their face masks. If they have an enclosed office, their own office, they can close the door. You know, they can take it off, but they have to remember that they have to put it back on, right? When they leave their office. And should people be walking in and out of that office where they have no face mask? You know, it's an enclosed space and they've been breathing that air. You know, maybe that's not such a good idea either.
Well, we have a question that says, we have a break room that allows employees to use for eating and a place to go during breaks. Do we require masks in the break room?
Yes, you would require masks in the break room. And you may want to, you know, part of the regs also is you have to evaluate these types of spaces. and you may need to be doing a schedule of people using the break room. You know, are 10 people going to go in the break room because it's 12 o'clock and it's lunchtime? Maybe we shouldn't be doing that. Or we probably absolutely shouldn't be doing that.
Someone says here, a recent mask order from the state says they have to wear a mask in a room of 2 or more. I'm not aware of that. Are you?
No, I'm not aware of that particular order, but to Eric's point, I don't think it's a bad idea to require people who may come in contact with each other to wear a mask at all times.
Yeah.
I just don't.
Yeah, and that's one of the issues. There's so many state regs, local regs. I mean, we blink and it's shifted, you know, slightly. And I just think that we really just need to be as diligent as possible with face mask wearing, especially. It's easy, you know, make everybody do it. You know, maybe the exception is they have an enclosed office, you know, when they're doing it. Also, you know, we always have to take into consideration disabilities. If they give you a disability note, you can't wear one. You know, we have to take that into consideration. Those types of things. But but it's hard to police in reality. I see they want to do the right thing. They try and do the right thing. Monday, everything's great. Wednesday, everybody's a little bit lazier. You start seeing people pull it over and it's just their nose is sticking out, you know. And before that was like, you know, that's not a good idea. But now it could be a complete OSHA violation with a penalty that goes with it if there was an inspection.
Yeah. Do we know what the penalties are for OSHA violations? Yeah.
So a general violation under Cal OSHA, and there's federal OSHA and Cal OSHA. I'll talk about Cal OSHA because it's more, of course, it's more restrictive and more penalties. So Cal OSHA is about 13,200 and change for a general violation, which would be a violation of one of these regs. A serious violation, which would be up to 25,000. A willful and repeated violation is in the 130,000 range. That's just for one violation. Right. So this isn't chump change, you know.
And like, remember, they can shut you down.
They can with these regs with under 685, they can immediately shut you down. And ask questions later. It used to be they was it 15 days?
Yes, 15 days.
Now it's like, sorry, we're not taking a risk. You're done.
That's scary, man. That's scary. The government can shut you down. I mean, I know you can appeal, but
you're shut down.
Shut down. Yeah. So you might as well get it right. If you're going to have people in the workplace and that have to be in the workplace, you might as well get it right now.
Yep. And err on the side of caution.
Yep.
Fair enough. Here's one about travel. If the employee reports to a main work site, but then is transported in an employer-provided vehicle to a specific location to perform work, must the employer follow the Cal OSHA regulations related to employer-provided transportation?
Yes.
Yes.
You know, I meant to look that up because employer-provided transportation is a flag for me as a workers' comp guy. It's an exception to the going and coming rule. Employer provides the transportation. There's all these different ways employers can provide transportation.
Right.
They can reimburse the travel. They can give you an employee car. They can impliedly necessitate that you use your car. And how far does it go with the Cal OSHA regs? I mean, what constitutes employer-provided transportation?
Well, that's a good question. I mean, the hypothetical you just gave, or the scenario you just gave, is typical. They drive to one spot, a parking lot, and then they're transported in some type of bus or van to the work site. That's, you know, that happens, you know, a lot. And there's specific guidelines for that scenario. They have to be distanced, you know, when they're waiting for the bus or van or whatever it is. It has to be open air, so you have to roll down all the windows. You know, they have to be, you know, separated as far as possible, you know, that type of thing. So they actually specifically address it. Now, how far does it go with employer transportation? You know, is it the carpool? You know, that people are using an employee vehicle to carpool? I don't know about that.
I would say, yeah, I think maybe not.
No, I mean, but again, you know, how far do you want to push this to be compliant?
I'm looking at the reg now. It says during the course and scope of employment provided, arranged for, or secured by employer. Provided, arranged for, or secured by employer. That's pretty broad.
It is.
including the rideshare vans or shuttle vehicles, carpools, private charter buses, regardless of the travel distance. So this language to me seems pretty broad. I think you have to think about that.
I agree. And if an employer is arranging carpools,
Right.
I
Yeah.
think it applies. If two employees decide to carpool, I would say it doesn't.
Yeah.
Or incentivizing carpools?
What's that?
Incentivizing carpools, like you get the $20 at the end of the month if you're driving in a carpool. You know what I mean? How about that?
Yep.
Mentioning,
I think you're taking some
Encouraging.
responsibility.
Yeah, I do too.
I don't know. It's not well defined, but we'd have to see. One person asked, employer provided transportation includes personal vehicle of the employee when she is reimbursed for the usage mileage and when she is driving with another employee in the car.
No.
Reimbursed
No.
for
No, everybody's when they're for the
No.
reimbursement of mileage for doing work. I mean, typically you're not reimbursed for commuting. That's
Okay.
not a reimbursement. But when you're traveling for work, that's typically reimbursed expense. That doesn't mean it's employer provided transportation.
Exactly.
That's a requirement under the law that they reimburse you for the 50 something cents or whatever it is.
really slowing down on the questions here. We're only up to 183.
Seems like we answered everything. Great.
No, we got a few more. We're gonna zoom right in at 1 o'clock, and we're gonna be pretty happy, I think.
Okay.
The training. Are there any requirements on how the training mandated by these Cal OSHA regulations is provided?
How what's in it? Yes.
Yes.
It's very specific and it's in the book.
Okay.
How it's provided is not. Now, like we said, there's a training link provided by Cal OSHA that would be free. How you do that? Do you do it when on the employee? You definitely would pay for that period of time. So if the employee is getting trained on it, it should be during working hours, right?
Okay.
It should be during working hours.
Well, I should be, and I guess a mandatory attendance.
Yes.
Mandatory attendance.
Yes.
It's
How do you
like
track that?
it's akin to sexual harassment training. They have to do it. Has to be trained. There's certain requirements for it. Everybody has to show up. It's mandated.
How soon do we have to train employees?
It doesn't say that I recall, but I would, since I think it's now available on the website, I would start rolling it out immediately.
Yep.
Technically, these regs go into effect as of 12/1. So technically, you got to do it right now.
Yeah.
But as you said before, there is some leniency of employers who make reasonable efforts to comply within the period of time. The strong,
I want
attainable.
email.
What's that?
I want email confirmation from you that you affirm that you watched the COVID webinars on this link to the Osha website.
Yeah, or a signed attendance sheet or signed, certification.
That's good enough? Because I'm just going to send an email saying, yeah, I watched it.
Well, that's the problem. The training is not going to be monitored, right? It's on a website. So, as long as you have a paper trail that you've required it of your employees and that they've confirmed that they have done it, I think that's enough.
I do too.
Yeah.
Yeah, I do too.
Okay, let's see here.
And if they lied about it, they violated a policy and they can be written up.
So training would not need to be negotiated with faculty association, correct? I don't know what a faculty association is.
Oh, unions.
Oh, unions.
Yeah, no,
I don't
No.
think.
no, it's not a matter of negotiation.
Yeah.
Not
it's
mandatory. It's not a mandatory subject to bargaining at all.
Okay. What do the regulations say about my responsibility for recording COVID-19 cases? I think we talked about this earlier.
Well, the regulations now require that all COVID-19 cases be recorded,
It says,
written down,
Yeah.
right? And there's certain information you got to keep, like the name, where the employee worked, occupation, when they tested positive, that kind of thing. That's required of all employers.
Right.
And this is separate and distinct from employers' requirements to record cases per log 300. right? You just keep this for yourself. You're not turning this in. If Cal OSHA comes in, they're going to ask for it. But that's the requirement to record cases. It doesn't matter if the cases are work-related. It doesn't matter if they got them somewhere else. You just record every positive case and the information necessary.
Oh, someone here said Cal OSHA's online training provides a certificate. Cal OSHA will ask to see the training record, so they'll need something in writing as proof.
There you go.
I mean, there's a certificate. That's great,
That's great.
right?
Yeah.
So they're the ones doing the work to make sure the employees actually watch it.
And it's free. Yay.
And it's free.
Okay. You know what? I think we're coming to an end here. I've got some more questions, but trying to sort out which ones are the best to ask. I'm sorry. Can you put up a link to the Cal OSHA training? No. Just go to the Cal OSHA website.
And it's on our ebook also, I believe.
I think so, yeah.
Is it in our book? I'm looking to see if we posted this on the chat. I don't think we did.
If not, we can update it to our FAQs of where to get the training.
Sure.
You can put a link in to go to it.
Mhm.
I invite everyone to, we've been posting as we go, different links. So the facts for today, the model plan, the address of the ebook that we have, and some of the other templates we have too. So I invite everyone to look at those and see, because people have been asking over and over again in the questions to, can I have these documents over and over? So that's why I'm continuing to reconfirm. Okay. Oh, and there is, someone asked, where can I find the training? And you go to https trainingacademy.di.cal.gov. So that's where it will be.
Yeah, it also looks like a link might have just been put into the chat.
Yeah, is it okay for the Cal OSHA training?
Yeah.
Okay, very good. Okay, I think we're just gonna have to call it. We're about out of time.
Great.
I want to reiterate, well, first of all, I want to say thanks a lot to Lisa and Eric. You know, I feel like this is just the right amount of time because look, we didn't get through all 194 questions, but we were able to sort of ferret through and get to the main points, I think, which is pretty cool.
Yep. And we'll continue to update the book and the frequently asked questions section. So check
Well,
that.
I mean, we update that book all the time, and I really recommend you bookmark it and use it. If you have a question, it's almost certainly in there. And if it's not in there, or even if it is, sullivanattorneys.com. It has our email address. You can email us to answer any questions that you have.
Mhm.
I want to also remind you that we said halfway through that we're doing our next webinar. I think it's a week from Tuesday. We'll be advertising it shortly, but it's going to be on vaccines. I'm really excited about that. We have a doctor there, an immunologist, who's going to help us walk through those issues. And then also talk about, like, you know, we're looking forward to 2020. So what's going to happen? You know, I mean, vaccinations, what are employers supposed to do with that? What about return to work? You know, what requirements can we have? What notifications can we have? And hopefully it's going to be really exciting I mean, you know, as exciting as a webinar can get. But hey, thanks a lot, Eric and Lisa. It's been a lot of work, and you guys have really stepped up and helped us think this through and articulate it and given us the tools and the information. And I haven't been reading all the comments, but it's hugely appreciated by the people out in the industry. I'm getting about 87 messages about how wonderful we are and saying thank you and all that. So it's really gratifying.
It's our pleasure. Thank you.
Our pleasure. Thank you, everybody, for attending and asking such good questions.
You guys want to hang on, we'll do a post game, but everyone else, this is the end of the webinar, so we're calling it quits. Thanks for attending.
Thanks, you guys.